Everyone, and I'd like to open this webinar or this fireside chat. Really, it is on using casuals, what the changes mean. If you don't know me, I'm Greg Harford, the Chief Executive of the Canberra Business Chamber, and I'm joined today by John Tuck, who's a partner at King & Wood Mallesons, and Miranda McMahon from Miranda McMahon Strategic HR Consultants. We're going to have a bit of a chat, really, about casual employment, what a casual is, how it differs from a permanent employee, and most importantly, talk about some of the changes that have come into play through changes to the Fair Work Act over the last 12 or 18 months. It is important that businesses stay compliant with the rules, that they know what to do, and it's great. We've got a couple of fantastic experts to help us sort of unpack these issues. So just a couple of housekeeping matters. We have got a Q&A function at the bottom of your screen. So if you have any questions that you want to ask as the webinar goes on, please just drop them into that online Q&A function, and we'll get to those as we go. But in the meantime, I'd like to introduce to you John Tuck. So John, as I say, is a partner at King & Wood Mallesons. He's a leading expert on complex workplace relations matters and litigation. He's an advisor to boards, major businesses and government on strategic employment safety and industrial issues. So John, great to have you here. Thank you so much for joining us.
Thank you.
And Miranda McMahon from Miranda McMahon Strategic HR Consultants is a strategic HR business partner with extensive experience across both not-for-profit and for-profit organisations. She's worked with Air Services Australia, Boeing, Seeing Machines, and part of Miranda's specialty is shaping workplace cultures and optimising HR practices for success. So great to have both of you with us. Thanks for joining us.
Thanks, Greg.
Now, look, John, I'll start with you. Let's go right back to basics. What is a casual employee, and what's the difference between a casual employee and a permanent one?
Thanks, Greg. And hello, everyone who's joining us today. I thought I would go, this sounds like a topic that you could wonder how we're going to speak for an hour on casual employment, but it is an area that has changed significantly. And for a lot of businesses, it has become a very complicated issue in relation to the nature of employment. For many of us, was the first way in which we entered the workforce. That's our first job, was probably a casual job. And it has been placed in a position where it has become quite complicated. And the policy drivers towards that have been rather to avoid the situation where, I suppose, responding to the idea that there's been some abuse of the concept of casual, the idea of casualisation of work, and a response to that issue of people being too insecure in their employment, and therefore we will make more stringent the rules and the access to casual employment. So the basic way in which the Fair Work Act has now deals with this is to actually try and define casual employment. And it has done so by coming up with this concept of firm advance commitment. And I'll come to that in a minute. But I just want to set the ground rules. I mean, we in Australia have always had essentially full-time employment, being someone who works on an average of in excess of 38 hours a week. We've had part-time employment for people who work less than 38 hours a week. And we have casual employment. And casual employment is that type of employment which is not subject to a firm advance commitment and creates this sense of you're available to do work, but you also have the ability potentially to say no to certain types of work. And it is that relationship which is more undefined, but in many ways, of course, it is it has a lot of the characteristics that part-time employment would have, and sometimes what even full-time employment would have. But the compensation for not having access to leave would be that you get a loading, and that has been largely the system that we've operated in Australia for many, many years. And casual employment takes up a very large proportion of our employment base. And the other type of employment we'll all be aware of is fixed-term employment. So to deal with this sense of insecurity in employment, the closing loopholes legislation introduced a definition of casual employment, a casual employee, and it's set out in section 15A. And I'm just going to take you through some of this. And the Fair Work Ombudsman, as well as the Fair Work Commission, both publish substantial amounts of very helpful guidance material on how to employ people as casuals, the difference between casuals and full-time and part-time. And it talks about the test, and it tries to give people help in their day-to-day practical issues about how do I employ someone. And so those are the best sources of information for you, because the Fair Work Ombudsman, if you're using their materials, will at least understand that what you've tried to do. What we're going to try and do today is to take you through some of those materials in the sense of the concepts of what is a casual employee. Casual employee, the way in which the Fair Work Act comes at this is to say that you're only a casual employee if the employment relationship is characterised by an absence of what's called a firm advance commitment to continuing and indefinite work. Now, there's been a lot of talk about what's a firm advance commitment, and there's some rules in the Act, which I'll take you through very quickly, but there has been commentary that suggests that what is a firm advance commitment is in the eye of the beholder. But it is really, that is the test that we have to get across, that concept of whether what I'm offering as an employer is a firm advance commitment, but or is it one that the nature of the work that I have is much more indefinite? It's one that is much more difficult for me to give it a firm advance commitment to, and therefore I need this sense of I'm not sure how much I'll need. I know that I need people to help me through a period of time. I know I need people to help me through peaks and troughs, but I don't necessarily have what I can define carefully as a firm advance commitment for this type of work. And some of the things that we'll talk about later in this session, Gregor, will be about the circumstances where actually these are fine lines that we're talking about, the difference between one and the other. Sorry, Greg.
Sorry, so I was going to say a lot of that comes down to kind of effectively that firm advance commitment, essentially an obligation on the employer to offer a certain number of hours, but also on the employee to turn up and accept those hours.
That's true. It's both, and it's that sense of, from the employer point of view, it's being able to determine that I will need this role carried out over this period in a predictable way.
Yeah.
And then to be able to be in a position to make that firm advance commitment for that definite work. Yeah. And where you don't have that, then you have this concept, well, that might be a casual. The other part of that test of what is a casual is that that person in that classification will be entitled to a casual loading.
Yeah.
And so that's the compensation for essentially not being able to access annual leave.
Yeah.
Entitlements.
So Miranda, from bring you into this for this, I mean, from an HR perspective, why would an employer prefer to employ a casual staff person over a permanent one?
Sure. So from a HR strategy perspective, I thought I'd discuss 3 key reasons that businesses might prefer casual staff. So the first one's flexibility. So casuals allow businesses to scale their workforce up or down quickly, depending on seasonal peaks, special projects, or unpredictable workloads. So I thought I'd give you an example. So if you had a receptionist who was going on leave for 2 weeks, that would be the perfect opportunity to bring in a casual to fill that role for a short-term 2-week period. The second part would be cost management. So as John referred to, casuals, when classified correctly, don't accrue entitlements like personal leave, annual leave, or redundancy payments. So this can also help you to manage your leave and redundancy accruals on the cost management side. They're also a great way to cover irregular shifts, so your evenings, weekends, last-minute call-ins, because these sometimes can be really hard to fill with permanent staff. So especially for industries like retail and hospitality, they rely heavily on casuals during busy periods like Christmas and Easter. But that said, under the closing loophole reforms, businesses need to ensure that casual engagements are genuine, which means, again, that no firm advance commitment to ongoing regular work. So my recommendation is to ensure that you monitor your work patterns proactively.
So, I mean, the whole basis of work in this country has been predicated essentially on the idea of a full-time job, 38 hours a week, ideally sort of Monday to Friday, 9 to 5 kind of thing. But casuals are really to fill the holes that don't fit that standard definition. John, do you think that that's a fair way of putting it?
Yeah, I think, look, it's there for those jobs that, and look, casual employment has come up in retail, it's come up throughout hospitality, is a huge employer of casual employment. And traditionally has always been that way because they're the jobs that are hard to discern, particularly in hospitality, as to what will be the demands on my business. For the smaller size business, even ones that are much bigger than 15 employees, you are still trying to determine, well, I am not sure what the peaks and troughs will be in any particular months. I hope and expect that it will be work, and I can't, I'm not in a position to offer you a permanent work, but I do know that I will have shifts, and I am not entirely sure exactly when those shifts will arise. And so I build a pool of casual staff. And that has been a really important part of our society, an important part of work, and an important part in which many of us first enter the workforce. So that remains, and it still is an important part of anyone's business and the way in which you structure your business. It's just that the rules in relation to it have just become that much more complicated.
Yeah. So talk us through that. Casuals have obviously been around for a long time. The government has passed some changes to the Fair Work Act, known as the Closing Loopholes changes, over the last little while. Can you give us a brief overview of what those changes mean and what employers need to be thinking about now?
So there's been changes to the definition of casual employee with the concept of a firm advance commitment. And then there's a number of other issues that arise in terms of how do you make that assessment. And for most people, yes, it shouldn't be difficult. But there is a concern that for some employers, it is actually quite a difficult burden. Now, I'll take it through in simple terms. We talk about the firm advance commitment, indefinite work, entitlement to casual loadings, but the Act then goes, well, tell me then, it gives you a list of indicia to determine what how the general will apply. And it goes to, you look at the substance. Now, the High Court recently looked at the issue of employment and casual employment in JAMA second personal contracting, placing heavy weight on the nature of the contract. Now, these rules change that and take you back to the multi-factor test of, let's look at the real substance and practical reality, true nature of the employment relationship. That's the language of the Act. That is, for some, that is not easy language to apply to any situation and come up with a clear black and white answer. That will often lead you into the grey. The firm advance commitment, that also then requires what's the mutual understanding at the time you employ someone. Was that what did the employee understand? What did I, the employer, understand? And what was the expectation between us? And you have then, a look at things like, do you have the ability to refuse a shift? And do I have the ability not to offer you a shift? And looking at the nature of my enterprise, is it reasonably likely that there will be future availability or not? And what will the nature of that future availability be? And are there full-time people and part-time people also performing the same work as the person that you're going to employ as a casual? And from the casual employee's perspective, they will say, well, I'm doing this and you've also got people doing the same job and they're part-time. Why am I different? So there's some of the issues that are now part of this concept of a pathway to permanent work that is now under our Act. And they're the trigger points that we can come to, Greg. But that is quite a different, more difficult thing to do because this is an assessment that goes right through the whole of the employment engagement. It's not a point in time only assessment. It's a point in time at the beginning, but then it's an obligation that you have throughout the relationship. And that's quite different. And it's quite onerous when you think about all those various indicia and the elements that the courts will take into account to determine whether someone is truly a casual or not, because the big impact, of course, is, well, what do I pay?
Yeah. It seems to me that the changes really are predicated on the idea that everyone should be in a permanent role rather than a casual one. But actually, is that what employees want? And obviously, it doesn't suit all employers. But Miranda, from your point of view, dealing with employees, what's the general feel on the street?
So the general, I think, in my opinion, employers ultimately want their workforce to match operational needs. So if we look at casuals, so casuals are ideal when flexibility is key. So as I said previously, for fluctuating workloads, project work, and unpredictable needs. When if we look at permanent staff, on the other hand, they're preferred when you want stability, skill building, and really strong culture development. So since the reforms, you need to be more deliberate with monitoring casual work patterns, even if an employee hasn't asked to convert to permanency. So if regularity develops, review the arrangement, discuss the options, and document everything clearly. So in other words, managing this well is no longer just best practice, it's really critical in compliance.
Okay.
Well, I think that's a good point, Greg. I mean, it really is. And Miranda picks up that idea that you've got to monitor your arrangements. They're not set and forget.
Yeah.
But to the point that you raised earlier about whether or not, the policy is to drive out casual employment, the government certainly says that's not what it's doing, but it is saying that what they don't want is people who are entitled to be part-time employees in permanent relationships with and that is the true nature of those relationships, not being characterised appropriately as such, or not having choice to become one. And that is the difference. But what we're still seeing is there is a very large number of casual employees still in Australia, and you should still feel, if that's appropriate for your business, that you can employ people on a casual basis. But there are some changes happening.
Yeah. So over the last 12 months or so, as the changes have come into place, John, how have employers responded to the legal changes? What have we seen happening on the ground?
There's been no doubt, Greg, that there has been some major employers have reflected on their arrangements, and they've either said, we will move people into part-time arrangements to avoid the complexity of the, I suppose, what we call the employee choice pathways and the obligations on us to continue to monitor, and potentially the uncertainty that we might have, that the arrangements we have in place might fall into the part-time characterisation as opposed to a true casual employment arrangement. And to avoid that potential complexity, people are just taking that choice off the table and employing people as part-time. Now, that's happening for some very large businesses where they do have very predictable workflows and predictable needs, but they are therefore then saying the option to come and work for us as a casual is no longer there. We're going to employ you as part-time. Now, that clearly doesn't suit everyone, but that choice has been removed from those people to be casuals because of these rules, of the complexity. So some people are saying, I'm looking at my workforce and I'm listening to what Miranda was just saying before, saying, well, that's too hard for me. I think I'm just going to make everyone part-time. So that's happening.
Yeah. Miranda, does that match up with what you're seeing in the market?
Yeah, definitely. So there are three main ways that we've really seen businesses respond. The first one is moving away from, as John said, the set and forget casuals. So defining roles more clearly from the start. Second, we're seeing they're taking a structured approach. So they're reviewing the casual engagements, they're updating the employment contracts, they're checking the awards, and they're improving the rostering practices. And thirdly, they're becoming really a lot more proactive. So they're tracking the work patterns every 6 months, documenting the casual conversations, and really starting to address issues early. I suppose my point is if you're unsure, seek advice quickly. It's really easy to fix a small issue early than have to deal with a back pay or a dispute later.
All right, well, let's talk about some of the specific challenges that are associated with bringing or transitioning casuals into permanent roles. John, what legal risks are there when businesses are looking at this, and are there compliance concerns to consider?
Well, I think in the current environment where there's been such a significant focus on compliance, particularly wage compliance, and then we have now wage theft laws. And so the obligation to get these things right is very, very high. And there are a lot of, I suppose, complexities in relation to the award system, rates of pay, together with now the proper classification of employees that have always been a challenge for our payroll systems and for our employers, even with the very best intentions. So the critical things remain. I need to be able to understand and explain why I've engaged people in a certain classification and characterization of the nature of the employment, whether it's part-time, full-time, fixed term or casual. And that is really, really important today, that I need to be able to do that and understand, because what flows from that are certain entitlements under the awards and the national employment standards. So I need to be able to characterize someone appropriately, because I then have obligations on me as an employer to pay them certain terms and conditions based on that assessment that I've made. And so casual employees will be paid at a casual loading at a higher rate of pay for being a casual. So that they get a specific rates of pay that are different than part-time. Part-time will be a lower number, but then part-timers will have certain accruals that casuals don't in terms of leave, notice entitlements. And so it's important to understand that what you pay someone based on that characterization differs. And it has created a lot of difficulties in the past in terms of classifications and the characterization of someone's employment. And the Fair Work Ombudsman has dealt with this across all sectors of Australia. And so the challenges remain, and the criticisms, I suppose, are that, yes, it's the idea that we're trying to give people a pathway to permanent employment is one that is not criticised from either side of politics, but the complexity around the way in which you've sought to do that has created real difficulties for businesses who simply want to employ people on a casual basis and not have this ongoing complexity about whether they're getting it right or not.
So, Miranda, from your point of view, what are the practical steps that employers should be taking to make sure they're complying with the new rules and making sure they've got those transitional processes underway?
Sure. From a HR's perspective, there are several critical steps that businesses should take. So review current casual engagements. Are they genuine? Are they ad hoc? Really importantly, update your employment contracts and ensure that you separate the base rate from the casual loading clearly. Check award and enterprise agreement obligations. We talk about a 25% loading, but that's not automatically correct. It does depend on what award your employees sit under. So do make sure that you're getting the correct loading correctly. Issue the casual employment information statement, so the CIS. So we need to make sure that that's given to the employee at the onboarding. Again, at 6 months, again at 12 months, and continuously 12 months after that. So that's a really important step to make sure you do that. The other recommendation is audit your rostering system and avoid regular systematic patterns unless deliberate. And really importantly, train your managers to avoid offering security of hours informally. So make sure that your frontline managers understand the difference between a casual and a permanent staff, and document everything carefully, especially when you're doing the casual conversion requests and decisions. And you need to make sure that you respond to that within 20 days of the request in writing.
So just to be clear, in the olden days, a couple of years ago, before these changes came into force, as I understand it, you had to offer casual employees a pathway to to a permanent role every 12 months or so. But that's no longer the case. It now has been flipped on its head a little bit. Is that right, John?
That's right. And so now we have it's a couple of things. First, it's an ongoing assessment to get right. That is, you still have an obligation to be properly characterising your employment relationship. And secondly, you have these obligations 6 and 12 months as a rolling obligation where you have to engage as to whether or not an employee is offered the opportunity to move into casual employment, but the employee also can give notice about wanting to become a permanent employee. And that is still based on whether or not the underlying characteristics of permanent employment exist, and that is the predictability of shift patterns. But for larger businesses where you have people being rostered on regularly on certain shifts and certain days at certain times, then it is much more difficult. Now, what happens and what might be happening anecdotally more regularly, particularly where people want to remain casual, is that they are moving around the shifts in which they work. So you're having this artificial layer of complexity happening where people will be instead of doing it every Thursday shift, will be shifting that throughout the week artificially between other people to maintain that casual engagement. And that's not something that really makes sense to anyone really as to what's the public good in that. But I suppose the big change is now that the Commission has been empowered to deal with disputes in relation to this, and that they can, that employees can seek to bring a matter before the Commission by giving the notice, and then the employer then has an obligation to respond in writing whether they accept or don't accept a change, and to give explanation for that. It's not that the Commission has been flooded with these applications. I don't think that's the case at all. But it is, I suppose, the fact is what drives your decision as a business as to how you engage people and what you want to do, is that is part of what's happening in the background of, well, that's an obligation. The Commission is now empowered to deal with these issues. The employees can raise the issues. I will then have to respond. I might be able to say, well, they still meet the definition of casual employee. I still can't give a commitment to their shifts. I can't make that future commitment because and I can explain to you what the nature of my business is and why I can't do that. And those things are important because you don't want to break the rules in relation to any awards you have or any enterprise agreement that exists in your business. And so you also got in mind to, I don't want to breach anything and have a civil penalty for breaching it.
Yeah. So a question for both of you, perhaps. I mean, anecdotally, there's certainly plenty of people out there who are working fairly regular shift patterns. They are casual employees. They seem to be pretty happy with that because periodically they might want to take a day off or a night off from their jobs to go and do whatever it is that they need to do. They like the extra loading that they're getting as a casual employee. Everyone's quite happy, but is there risk to the employer for not stepping through a process of transitioning them into a more permanent arrangement?
Well, I think there is, Greg. I mean, it's the obligations you have in terms of accrual leave, for example. If someone is properly entitled to be characterised as a part-time employee and effectively they're permanent staff and you're not paying them as such, there is a complication that you haven't accrued leave. Now, that can create very, very significant problems where you have a very large number of people because you won't necessarily be able to set off the casual loadings against those leave entitlements. And so you leave yourself in a position, as has happened and in certain sectors of the Australian economy, that where you had very, very large liabilities accrued by reason of the characterisation of someone being incorrectly made. And so that is a real risk that you end up seeking to accommodate people's desires as well as your as a business saying, well, I'm happy to allow people to do that. But you also then, you are running all the risk, not the employees.
Yeah. And where does that risk come from? It would require a complaint from the employee.
But it's simple as simply notifying the Fair Work Ombudsman. So it's not a difficult exercise for someone to raise an issue with the FWO, and for that then to trigger an inquiry into your business. So it's a very low bar to trigger the regulator's interest, and that's not necessarily a bad thing. That is an easy access, but you shouldn't assume that it is a difficult bar for people to climb to notify the FWO.
And I think, Greg, that's where we talked about documentation's really, really important, so that you've documented that you've had the discussions with the employee, that they want to stay as a casual, the contracts are correct, so that you're making sure as an employer that you're doing everything correct, so that when it doesn't land in John's lap, that everything has been abided by in regards to the policies and procedures.
Yeah. So, John, legally, is there anything additional you'd be recommending for businesses to help protect themselves to make sure that they're treating casuals fairly and appropriately and consistently under the new laws, apart from getting that documentation right and continually reassessing the position?
Well, I think that they are the most important things, Greg, because what you don't want to be in a position there are some very, very stringent penalties for saying something false to convince someone who might be a casual or full-time employee, a full-time employee or part-time employee, to enter into a casual arrangement, or threaten to dismiss someone because they're a casual employee. So there are issues around, well, I can't enter into a sham arrangement, and I can't do certain things to threaten someone because of the nature of the employment that they seeking to exercise their workplace rights. So that overlay is really important, and the Fair Work Ombudsman has been empowered and essentially has on its website information to say, if you think you're in a sham casual arrangement, we can help you. If you think you've been properly mischaracterized, then you should talk to us. And what they do in terms of advising people of whether they are or are not properly characterized as casuals, then they list them through: do you work regular hours? Is it predictable? Do you have long-term rostering arrangements? Are there other people doing the same work as you do who are on different arrangements than you are? And that invitation for people to be better informed, and I think in this environment, Greg, people are becoming better informed. There's no doubt that the very simple and entry-level AI tools that are available to people now through even a Google search are significantly more sophisticated than they were 3 or 4 years ago. And I know that my clients come to this in a way of, I want to be compliant, I want to do the right thing, I want to make sure that we're doing what's required of us under the law. We're not looking to make things move into the grey. We're just trying to make sure that we've got work to be done. We've got people who want to work. We want to engage them appropriately, want to pay them appropriately. But for people who are unsure, and it's the uncertainty, I think, is the issue, Greg, that in this area, people have much better access to information than they previously did. And the expectation is that you also access information, and where you have issues and need advice, you reach out to people to give you assistance. Now, that can be Miranda. Certain clients reach out to us at King & Wood Mallisons around their labour force planning, and they do look at these bigger issues around, we have a 500 or 1,000 casual employees, we have 2,000 part-time. We want to assess, is this a sustainable business model for us? Can we run this labour model in the future under these laws? What's the complexity that we now have to do in relation to our casual staff? Does it actually make sense for us anymore to employ people even as casuals? And do we move them into a part-time arrangement because it's more simple? But equally, I think people are becoming much better informed and have much greater access to information about their own entitlements. Now that can be a good that should be a good thing because people are better informed about why you're doing certain things, which should help the conversation. But equally, it can lead to disputation because people are not fully understanding and creating disputation and grievances around whether they're properly classified or not. Because it's not these, and when you have concepts such as future advance commitment, you have things that are quite nebulous, notwithstanding the indicia that the Act draws your attention to and asks you to work through, because each one of those things can people have different opinions on.
Okay, well, we'll come on and talk about perhaps some best practice that employers can consider adopting now. But before we do that, I just want to remind everyone on the call here that we have got a Q&A function. So if there are any questions you want to ask our panelists, please just drop them into that Q&A chat, and we'll get to those as we go through. And also, I guess just a quick plug for the Business Chambers Employer Advice Line as well. So we do have a number there available for members, 1300 277 881, and we're always keen to help our members talk through some of these issues and challenges. But Miranda, what from an HR perspective, what best practices have you been recommending to your clients that they should be adopting to be trying to navigate through some of the fog perhaps that are the changes to casual employment?
Yeah, so the businesses that are navigating these changes most successfully are taking a really proactive and structured approach, and they're seeing it as an opportunity to build stronger, more resilient workforces and not just ticking a compliance box. From what we've seen, the best practice businesses, they're doing a few key things. First, they're segmenting their workforce properly. So they're really clearly defining which roles are genuinely casual, and that's based on fluctuating and ad hoc needs, and which roles need permanent stability. So, for example, casuals are used for true seasonal peaks, while all core operational roles are more shifted to the permanent part-time when patterns are becoming more predictable. Second, they're making sure that they issue the casual employment information statement properly that I talked about before. So as I said, not just once at hire, but again, it's 6 months, 12 months. And also putting some systems in place to track it, because it can get, it can get lost and you forget to do it, etc. So putting a system in to make sure that they track it. Thirdly, they're auditing and updating their employment contracts that I spoke about previously. So making sure that casual loadings are separated clearly from the base rates, avoiding any hint of permanency promises, and really referencing casual conversion rights properly. They're checking the award obligations in detail. As previously mentioned, while the 25% loading is common, some awards have different rates, and others also change how casual loading interacts with overtime. So making sure that you get that right can also then avoid a serious underpayment risk that you might have. They're investing heavily in training managers and recruiters that I spoke about before. So making sure that they know how to communicate the casual expectations clearly without unintentionally promising ongoing work. And finally, they're managing a casual conversions respectively and proactively. So monitoring work patterns and having those open discussions, respecting employee choice, and again, documenting everything properly. So the really good businesses aren't waiting for the problems to arise. They're making sure that they act early, staying deliberate, and also using these changes to actually build a better, smarter workforce practices.
Okay. John, question that's come up, I think, is around the I think there's been mentioned a couple of times of casual and permanent staff doing the same job and that creating risk. But it is acceptable, right? And if you've got a fluid environment where you're having to bring extra resource in to deal with seasonal peaks, for example, it would be acceptable to have some casual employees working alongside your permanent part-timers. Sorry, you've just muted, John.
I was trying to do the right thing, Greg. Muting myself. It is. I mean, the very nature of casual work is that we're working alongside often people who are on a permanent basis. You might be doing the same work, but it is really around the ability to refuse shifts, not to be offered shifts. It's that other indefinite parts of the nature of the relationship that can preserve the reason that you are casual. And so those fluctuations in demand may very well be the reason that you are a casual employment. You're a casual employee, and that's why you've been offered those shifts in that particular way. And that is an authentic, genuine basis upon which to engage someone. And it's appropriate that in those circumstances, you can have people on different arrangements, still doing the same work, but it's the other issues and indicia that lead you to say, well, that's a casual employee. And I've documented, as Miranda has said, I've been very careful and thoughtful about what I'm doing and why. And I can justify why those people are casuals as opposed to these people who are permanent part-time. And they might be permanent part-time because I have that core amount of work to be done, but I am much more uncertain around these other peaks and troughs. And that is the reason why I'm employing people on the casual arrangement. But it still is, it's that the difficulty, I suppose, and the challenge and the criticisms of the laws has been that ongoing obligations to continually to review these situations, which create some significant difficulties for people, and that's where the uncertainty came. I mean, the High Court in Risotto was a really a foundational decision that people look to the High Court to clarify what the obligations were in this space. They've been changed, and the replacement of the laws are very, they're quite different and much more complicated and onerous.
Okay. Now we heard Miranda's views about some best practice stuff for businesses to be thinking about in this space, but from a legal standpoint, is there anything you'd add in terms of strategies or frameworks businesses should be implementing to avoid future disputes or litigation?
Well, one thing that Miranda mentioned, which I think is the thing that I always tell clients to engage with them on, is the issue of clarity around decision making and being able to document it. And so it's that clarity around what you're doing and why, and also where you can record the mutual understanding of you and your employee in writing, so that there is clarity about what you've done and why, and you've communicated that to the employee. Now, for larger workforces, it's that clarity around the nature of the work, the commitments that you can make. And really, as we go through the various indicia in Section 15A, it's looking at that and saying, well, I've looked at those indicia. I'm satisfied at a point in time that the people that I'm engaging are appropriately casuals. I will record the reasons why, not in the contract with them. My contract with them will be clear that I'm offering them a casual employment, but I will also have within my documents the way in which I've approached the workforce planning. And for larger businesses, that's something that you're capable of doing. And I think that's really important to be able to access that information as to why you have done what you've done. Because the Fair Work Ombudsman is trying to understand when they come to you, what are the arrangements you've got in place and why have you put them in place? And if you authentically can say to them, look, this is the nature of my business, this is the nature of my demands, this is any particular time is the way in which I've forecast the needs of my business. I've taken the step to offer employment to people on a casual basis because I'm not able at this point in time to be certain about the future demands. They fluctuate in this economy, but I have turned my mind to it, and I'm taking on people and giving them a job.
All right. So if I try and summarize that, it's about making that assessment at the outset. It's about documenting that, making sure you've got a shared understanding and continuing to review through the life of that.
And that's the continuing to review, Greg, is the tough bit. And it's the bit where the commission could take a different view than you. And it's that bit that has been the subject of, I suppose, criticism, that this is way too complicated and too onerous if I have to do this on a rolling basis, that I can't set and forget for at least a substantial period of time. And what's been required of me is far too onerous for the problem that's perceived around insecurity of employment. Not taking account of the fact that there is a significant amount of genuine casual employment that is both wanted by the employer and wanted by a very significant part of the Australian population who want that casual opportunity.
So it is hard to navigate through. Do you think there are further, I guess, looking at, in a crystal ball, do you think that we're here to stay with the current settings for a while, or is there talk of more change to come?
The changes to come will only come from the coalition side. So the coalition have not advanced significant reform in the industrial relations area, but one area that they have said that they would make changes to is in relation to casual employment, essentially trying to at least bring back that sense that the contract has a primacy within their relationship, which is the High Court in Rosado, and they mentioned that in their policy announcements. Michaela Cash is the opposition spokesperson in relation to employment relations, points that out, that they will revert back to the position that existed prior to closing loopholes, which was a less onerous and a point in time approach that can be changed. There still was a pathway to change, but not the I suppose complexity of the current arrangements, which people have been critical of.
Yeah. But just to be clear, I guess for our audience, I mean that's speculative on all our part.
That is the change that's been proposed by one side of government. The Labor Party and the Albanese government, as I understand, doesn't have any particular needs to change. There will be a review of the Fair Work Act and the reforms in the normal course of review of such significant reforms as to how they're operating. There will be an opportunity at some point in the future to say, well, on behalf of business, whether or not these reforms are becoming a barrier to entry into the workforce, whether they are making a significant change to improve the amount of permanent employment available to people. So there will be that opportunity in the future. But of course, in our government, getting labour reform through both houses of parliament is very difficult. And it's particularly difficult at the moment for and has been in the past, difficult for a coalition to do so when in government. Who knows what will happen on the weekend and into the future, Greg, but it doesn't look like it's going to be an area of legislative reform that is going to be easy for either side to make significant changes to. But there will be opportunities for business and probably the unions in the future to make representations in relation to the way in which casual employment is operating, because it is one area that has drawn significant attention in terms of the nuts and bolts of employment, as opposed to the collective labour issues and the issues around the rights of union delegates. This is a practical issue of, well, how do I employ people and not expose myself to significant compliance risk is an issue. And it's the compliance risk. Most employers are coming, I don't want to be stuck in a compliance dispute.
Absolutely. Now, look, there is a question that's come in, and I guess I'll just put a final call out for questions that might be coming in through that Q&A function at the bottom of your screen there. If you're jumping back, I think, to that situation where you've got both casuals and permanent people filling the same roles, if you end up with a vacancy in that permanent spot, are you obliged to offer that role to one of your casuals, or can you just go out to market?
You go to market.
All right.
Yeah, it's a simple answer to that. I mean, there's not a particular obligation that you have to give someone uplift, but of course it does. I mean, that's one of the grey things, isn't it? As to what's the nature of the work that I'm doing compared to that person.
Yes.
But it is meant to be a different job. It's a different nature of the role. It's permanent. You're obliged to turn up every week. There are things that come with it. I see you nodding, Miranda.
Yeah, I was just going to say, I think that's what we have to remember, that one of the main differences between casual and permanent is that casuals can say no, that they can't do that shift, etc. When a permanent employee, the expectation is, unless you're on leave or you're sick, etc., that you will be attending, you will do that pattern of shifts. And I think that's really important messages to what the differences are between casual and permanent. So there's no obligation from the casual side.
Comes back to that firm advance commitment.
That's right. Yeah.
All right. Well, look, just to close off, I guess, if you got any final advice, Miranda, we'll start with you for businesses in terms of navigating these changes. Anything else?
Yeah, sure. So the key takeaway is don't just treat this as a compliance exercise. It's definitely a chance to build smarter, stronger workforce practices. Make sure that you align your casual and permanent roles properly. As I said, audit your contracts to make sure that you're across your enterprise agreements and your awards. Train managers carefully so they understand the difference. And communicate openly with staff. Have those conversations with them. Talk to them. And if you have made a mistake, it can be fixed if it's picked up early. And be proactive. And that will set your business up for future success.
John, anything you want to add to that?
Look, I like a lot of what Miranda said because I think it is, and for the day-to-day work that people will have in front of them in payroll and HR and personnel, that you are just trying to make sure that your managers are well informed, that your documents that you're producing and helping support your business, your contracts are reflecting of reality and they're actually best, the state of art and they reflect the law. And then you want the people whose job it is to offer the employment and to bring people on, that they are paying attention to both sides of the obligations of a business. Not just I've got the person in, well, there's another side of the business about we've got to pay them properly. And sometimes people get the enthusiasm in the smaller size businesses that things fall between the cracks. And if people don't pay attention, and by the time they do pay attention, they may have a liability or something to unscramble. And the costs of that doesn't have to be a lot, but it's your time and effort and the disruption to your relationship with those employees.
Yeah. And ultimately, you need to have a great relationship with your employees, whether they're permanent or casual, right?
And these issues about pay and engagement are one of the things that has caused friction and it can be completely unnecessary.
Excellent. All right. Well, look, thank you very much, Miranda McMahon and John Tuck, for joining us today. It's been a really interesting conversation about casual employment and unpacking some of the differences, challenges, and the legal changes that have gone on. I've really appreciated you being here and having a chat to our audience today. Miranda McMahon from Miranda McMahon HR Strategic Partners and John Tuck from Kingwood and Mallisons. Thank you so much for joining us. It's been great having you here.
Thanks very much.
Thanks for having me.
Thank you.
Bye.